Joining me in the studio, I still have criminal defense attorney Sarah Becker here and retired Superior Court Judge Gail Tucson here. Thank you both so much. Watching that, I want to pick your brains about a little of what we saw with one of the Weinstein accusers, Ambra Gutierrez, an Italian model. We saw the clip there where she agreed to wear the wire after going to the New York Police Department. This was back in 2015. And in those tapes, we hear Harvey Weinstein seemingly admit to groping her on the day before. We know that the DA's office didn't move forward, the police department didn't move forward, whomever reviewed all of that material did not move forward. Ultimately, we're here and we're hearing about it now. But in 2015, what do you think? Do you think that was enough for them to file charges, get a warrant, and arrest him for sexual assault? What do you say, Sarah?
You know, I'm not certain that the audio from the recording is enough in and of itself, but certainly in conjunction with the victim's statement. I think we remember that oftentimes cases go forward on not much more than a victim's statement. And then you have a conversation with the alleged, with the accused, where his demeanor certainly corroborates what she's telling the police, in that the conduct that she alleged occurred was not consensual, that she didn't like it. And right. She's saying those things to him, and he's not saying anything in response that would make you think that that's inaccurate. He's not saying, well, you didn't mind yesterday. You didn't, he's saying, I'm sorry, I won't do it again, and things of that nature. So I think that the two things together would be enough to go forward on an unwanted sexual encounter.
Right. You make such an excellent point. Think about it. Think about any sex assault case we might have where you're having that direct testimony from the alleged victim, and that's all you have. You don't have a recording, or an admission on a recording that's done, in that way with police involvement, run by police, or you don't have a confession in a subsequent interview after the allegation comes forward. So it raises the question: wasn't there enough then? Judge, what do you think if you were the judge and you had police coming to you saying, look, we've got an accuser saying that this happened to them, they're willing to testify in court, we've got this wire and this is what it says, would you be likely to sign off on a warrant such as that?
I think there was enough, but I think in this instance, just like what the investigative journalist was saying, when you hear that, there just has to be so much more, and this is just the tip of the iceberg. And so I would say, as a judge, sometimes it feels like, the DA has just piled on and, why do we have this extensive indictment when, it just happened. Mm-hmm. But I think in this instance, they probably were prudent in pursuing it, taking a little bit more time, getting more victims so that when they bring him to court and it's time, if he's found to be guilty, to sentence him, you have enough there to really resolve this for a lot of victims, not just for one.
Sure. Anything else you'd like to add to that, Sarah?
Yeah. I think it's a really good point. As a defense attorney, certainly it's a much more defensible case for me if it's one allegation of touching someone's breast as opposed to 90 accusers or however many are going to be brought forward.
Right. I would love to pick your brains about the other case we're covering right now. So if we can switch gears kindly before we have to take a commercial break. We're covering this case in Florida, death penalty case, man accused of killing his mother, two half-brothers. And there were some reports that really swirled around this case based on what was in the actual search warrants. Detectives were looking for evidence of possible witchcraft, saying that this might have been the motivation for the crime. Wicca pagan evidence is literally listed as something that is part of what investigators were hoping to recover when they were searching the defendant's home. So I want to raise the question of relevancy to you ladies. The judge seems to have a really big decision to make here. We know that when detectives went into this guy's house, he had this worship room, and this was his religion, according to him, when they spoke to him. And what relevancy it might have with the crime is really arguable here by both sides. Give me your quick impressions before we have to take a break. Sarah.
It's probably relevant, but it's just a question of how relevant is it and whether it's admissible. because everything that's relevant is not necessarily admissible. And I think there's a significant chance that this is too prejudicial to be admissible, even if it's relevant.
Gotcha. Judge, your thoughts, please.
So I agree. I mean, it's relevant. There are circumstances, the things that he did that might have been part of his witchcraft, if that's what it was, were steps that he took to murder the victims. But he's not facing the death penalty because we believe he's a witch.
Correct.
He's facing the death penalty because he had 3 victims, because of his relationship, what he did afterwards. So I would say, you know, there could be a persuasive argument that it would be prejudicial and that they should just focus on what he did and, you know, if the motive was, in fact, for financial gain.
That's a great point to leave it on. You know, financial gain is listed as one of the aggravating factors. Cold, premeditated, calculated manner is another one for seeking the death penalty, but witchcraft as a motive is not. Judge Gail Tucson, great to have your expertise. Attorney Sarah Becker, great to have your expertise as well. Thank you, ladies, so much for being with us here on Court TV Live.